All right. Good evening, everyone. Thank you for joining me tonight, November 7th, 2023. It is election day for many of y'all. So I hope that if that is the case, that you have exercised your rights and have made your voice heard. I believe that is all I can say on the matter. I should just express yourself and hopefully you've done your research in anticipation. No elections here in DC this today, so I was able to avoid the polls for once, and also some of the advertising around all of the election complexities. So hope you are staying sane and safe while those conversations float around you, if that is the case in your community. Thank you to everyone for your flexibility in the time shift. Thank you for the two, four, five, six, seven, five, six of you that are actually in the room. And I hope that if this is a time that doesn't work for you, or if you are unable to attend the fellowship at all going forward, you would let me know that. I have had to reach out directly to a few students from whom I have not heard anything. So please know that as I stipulated at the start of the semester, my door is consistently open. While my hours have changed, I still remain invested and dedicated to the fellowship program. And so I'm here to support you. I want to know about the work that you are undertaking if and where struggles arise. So please know that I continue in this capacity at least through the end of the calendar year. Which raises another point that we are in conversation to determine what happens with the fellowship come January. I believe in the fellowship research identification form, I asked y'all to indicate whether you were committing to the fellowship for the year or just the semester. So if you do not remember filling that out, it is in column I as in indigo. Please revisit that because that data will be really useful in informing how we proceed. Again, that is in the spreadsheet that y'all have already completed. It is just an additional column. Are there questions, comments, concerns about that ask, about your research, any stumbling blocks or challenges that have arisen since last we spoke? Okay, you will note that next Tuesday, I do not currently have a speaker. So I am anticipating that being similar to our last open session, where we can talk about research updates, going around the virtual room, getting more information about what your research has uncovered. So you don't if nothing is coming up for you right now, that is wholly understandable. But I would ask that ahead of next Tuesday evening, you come prepared to give us all an update. Okay. I have updated the calendar with the newly confirmed speakers. Obviously, with the timing shift, not everyone was available. However, those that were have been updated in the calendar. So that is both linked in the meeting invitation and is also available in the shared folder. The updated Zoom link that I sent around a reminder for today through Discord as well as via email is the one that should be used going forward. So I know hopefully that didn't cause any confusion for y'all that I canceled one meeting invitation, but I didn't want there to be two Zoom links floating out there. I thought that it was confusing me, so wanted to create as much streamlined process as possible. Any questions, comments, concerns generally? Well, speaking of appreciation, I am delighted this evening to be joined by Miss Lauren Bonds. Lauren Bonds is the executive director of the National Police Accountability Project. Thank you so much for being with us today, Lauren. Prior to joining NPAP, Lauren was the legal director of the ACLU in Kansas. Before her time with the ACLU, she served as the Assistant General Counsel at the Service Employees International Union, where she provided legal support to the union's fight for $15 campaign. She's represented low-income workers in employment and civil rights litigation, including voting rights cases in Alabama and North Carolina. She received her law degree from Duke University and has held summer positions at the Texas Civil Rights Project and Equal Rights Advocates. I think I am just thrilled based off of that we have representation from NPAP here today, but I think at least for me, who has been watching the news cycle quite closely today, as we found that one of the officers involved in the killing of Elijah McClain was yesterday found not guilty. It is really heartening for me to recognize the work of organizations such as NPAP who try to promote additional awareness of what accountability can and should look like. And so I'm just grateful for you for being here, and also grateful for the work that you are doing in trying to advocate for greater transparency and accountability for those who allegedly are here to make us safe. Lauren has put together a PowerPoint presentation already, so I will give the floor to her to provide that overview. I have already uploaded that into our shared folder so that you have access to her slides. But Lauren, thank you for being with us, especially so late in the evening. I yield the floor to you.
Thank you so much, Jessalyn, and thank you all for being here, for being part of this consortium and being interested in this work. Mentioning Elijah McClain, I think is so important, because oftentimes we, really focus on these kind of technical fixes for policing, when I really think we're at a moment when we could benefit so much from zooming out and thinking about kind of what is policing, what is the culture, how did the culture get here, and what we can do to change those kind of bigger picture issues. So really excited to be able to speak with you all today, really excited about your interest in this area, particularly young law students. I'm always just like, hey, there's so much that your skills can do in this area. I'm going to go ahead and share my PowerPoint here, assuming I can do that without it getting too crazy. Okay. Oh, that's not what I want to do. I want to go slideshow. Okay, there we go. Thanks for bearing with me. All right, can everybody see my screen okay? All right, great. So I want to start off just by giving you a little bit of background on our organization. So the National Police Accountability Project, we're an organization of 550 lawyers and legal workers. And just about everybody in our organization almost exclusively represents people who've been harmed by the police or been harmed in jails and prisons. We have some people who have kind of combined practices where they do criminal defense work or, have employment cases here or there. But for the most part, everyone in our group is suing police and jails and prisons all the time. And so I think that should give you the scope, a little bit of a sense of the scope of the need for attorneys doing this work, that we have people who can sustain their full practices, 550 people who can sustain their full practices doing this work. And, just to kind of balance that out with something, another statistic, only about 1% of people who have been harmed by the police actually get an attorney to represent them. So the scope of the problem is very, very big. And, in addition to doing our work in the courts, we also advocate to end police violence in legislatures and by supporting grassroots groups that are engaged in direct action. And I think some of the perspective that we bring to the work from being litigators, from suing police departments, is that, a lot of the time when we sue somebody, that's kind of, you go through discovery. You guys are all law students. You probably have some familiarity with the litigation process. You go through discovery and you get, kind of all these documents from the police department. You get their training manuals and certifications. You get their policies, their handbooks, kind of all the guidance police officers had before they, encountered our client and ended up engaging in misconduct. And what we often find is the training is actually pretty good, and the policies were actually pretty good, and they actually were trained a lot, and still we had this outcome. And I think one of the reasons that that really helped us focus on accountability being our solution to police violence, is because we know that, American police are some of the most trained, law enforcement agents in the world, and yet they still have the worst outcomes. And part of that reason, is we think that there isn't really a culture of there being consequences, not cultures within police departments, not cultures, in courts. And really our work is focused on changing that. And I do think there is a question to be had. Just based on everyone I saw who's going to be speaking with you throughout at least this semester, I don't know if anyone's coming in to talk about, reimagining public safety and whether, the role of police generally. I really think, though, that those are kind of the only two outcomes you can have from seeing, the level of training that police officers have and the existence of these policies that have already been in place is, should police even be doing some of the roles that they're doing? And then also, how do we make them more accountable? Because the rules are there, they're just not following them. So on that note, I want to talk a little bit about the different types of accountability. We really focus on civil legal consequences, and we'll get into some of, the barriers and the reasons that hasn't, really stemmed police violence or police misconduct. But I'll go over a couple of other ones a bit more briefly. So one is criminal consequences. We spoke about Elijah McClain already. And that is essentially where there's a prosecution of somebody who engages in misconduct. Usually it's excessive use of force. Almost always it's a situation where there was a death or it resulted in a killing. And you all have probably been through criminal law 101 at this point. You got to prove your case beyond a reasonable doubt. You got to prove it to a unanimous jury. It's a incredibly high standard to get a conviction. And that standard is even higher when you're suing or when you're prosecuting a police officer who often has built-in state law protections into their ability to use force. And so, I think things are changing a little bit in this area post George Floyd. We're seeing more prosecutors taking a chance and going ahead and filing charges. But criminal consequences are definitely not something anyone can expect when they lose a loved one to police violence. And, that is because of that high standard of proof. And I think it's also because there is, we have to acknowledge that prosecutors are also part of the law enforcement ecosystem. They rely on police officers to be able to build their cases in other areas. And so, strategically, it often doesn't make a lot of sense for them to prosecute a police officer. Even kind of taking a step back from that, I think it's important to acknowledge that a lot of the types of police misconduct that people face is not, in the form of a murder or use of force, wrongful detentions, false arrest, sexual assault. I think there's a lot of different forms of police misconduct and police violence that aren't, ready candidates for a criminal prosecution, even if there is technically a crime you could sue or a crime you could prosecute them for. So there's criminal consequences. That is a bucket, I think, often of consequences that you see people advocating for in these high profile killings, but really isn't like a good fit for all the different types of police violence that we see, and really isn't pursued very often. Another kind of category of accountability is community consequences, like, there being some kind of social ramification for police officers who hurt people or harm people. And I think one of the major barriers for that happening is a lot of police misconduct is secret. It's confidential under state records and confidentiality laws. And so even if generally that police officers are doing harm in your community, you're not going to know exactly who's involved. You're not going to know kind of what the police department's response to it is. And so this is a really, unfortunately, underutilized kind of type of accountability just because of all the restrictions that are in place. And then there are employment consequences. If an officer, will be terminated as a result of engaging in misconduct or receive coaching or some other form of discipline, and then civil legal consequences. And I'll talk a little bit more about employment consequences, because I think one thing my clients are always really surprised about is I went in and I told the chief, or I told their sergeant, or I told their lieutenant what they did, and then nothing happened, or they like automatically took their side and said they did the right thing, even though it's very clearly not the right thing, or not the thing that comports with their training that we'll ultimately find. And so I want to talk a little bit about that, because I do think it really exposes the need for civil consequences, not only for individual officers, but for police departments writ large. So one thing I think that's important to know is that civilian complaints are typically handled by police departments, unless you have a really robust civilian review board in place. Almost all of the time, it's the police investigating the police for high profile or really egregious instances of police violence, like officer involved shootings. Sometimes that will be a different police department that conducts the investigation, or a different law enforcement agency, but it's still police looking into police. And so less than 10% of civilian complaints result in discipline nationwide. And you look at some of these cities that have really high rates of police misconduct, kind of known bad police departments, like Minneapolis, that was recently investigated by the Department of Justice. Philadelphia, that's had kind of a consistent stream of high profile, decades long police misconduct litigation, and you're seeing less than 0.02% in Minneapolis, 1% in Philadelphia. And just to talk about Minneapolis, take a step back, talk about George Floyd some more, just because I think that really has been a really transformative issue, obviously, or a case on this topic. Derek Chauvin had dozens and dozens of civilian complaints against him before he killed George Floyd. And, they all kind of went through the same process where, someone in internal affairs took a look at it and said, maybe this isn't exactly what you're supposed to do under our excellent policy or our excellent training, but, I don't want to deal with the union. I don't want to deal with, the consequences and all the hassle of enforcing what our rules should be. And the reason that we see that happening so often is, one reason is law enforcement Bill of Rights statutes. And so I don't know if you all have heard about these in the past. I think they're kind of one of the not secret, but not talked about enough barriers to employment accountability that we have in our country. And so law enforcement Bill of Rights statutes are essentially these laws at the state level that create all these minimum protections for police officers when they engage in misconduct. So one really common thing that they have is delays before an officer can be interviewed, restrictions on who can interview an officer. There's, some states have like mandatory dismissals of investigations if they take too long, or if there's any kind of procedural error. And so these bills or these statutes are a real issue, and they also set the floor for collective bargaining agreements. Union contracts in police unions are probably something that you've heard about as a barrier to police misconduct. They are often, put in place all of these really pretty severe restrictions that make it incredibly difficult to discipline a police officer without there being a lot of appeals and involvement and cost and time on behalf of the department. And oftentimes, even if you have a reformist chief, even if you have, police leadership that is really invested in improving the culture and accountability, the CBA is something they're going to run up against so often that it's going to make it almost impossible for them to do in any, really meaningful way. And that's not to say that, employees don't deserve due process protections. I'm a former labor lawyer. I think everyone should have a lot of process before they get disciplined or terminated. But what we see for police officers is just beyond the pale, especially compared to if you look at any other law enforcement or any other public employees. And then you have these cultural issues like the blue wall of silence, which, is just kind of the a cultural phenomenon that you see in a lot of different police departments. I know that you all are probably familiar with EPIC, peer intervention program that's been really successful with the New Orleans Police Department, and is kind of a part and parcel reform that's in consent decrees that the Department of Justice does. And I think that's really great, but I think a lot of police departments, even if they, you know, have mandatory intervention requirements and other things like that, it really hasn't chipped away at the culture of police officers, you know, saying that they didn't see anything, or, you know, just corroborating their colleague's story, even if they know it not to be true. And so that's a real barrier for, you know, investigators and internal affairs departments that want to do something and that want to hold their officers accountable. And so just to go back to law enforcement Bill of Rights statutes, 22 states in our country have LIBOR laws. And one of the interesting things is you kind of always see these laws get introduced and passed after there's been, you know, even just kind of mild efforts to pursue police reform. So there was a big push of, and a lot of LIBOR laws were enacted or strengthened following the beating of Rodney King and organizing that was a result of that. And you know, there's been kind of another push post George Floyd, with Georgia and Missouri both passing their law enforcement Bill of Rights statutes for the first time. I believe Iowa recently passed a statute themselves as well. And you know, we already talked about these procedural protections and how they really undermine a police department's ability to hold their own officers accountable. You know, having these mandatory cool-off periods before officers have to be interviewed so they can kind of get their story together, access to evidence and witness statements before an interview, which, you know, if every criminal defendant had what the police officers had on them before they had to sit down, they would fare a lot better as well. And so I do think that, you know, it's really important to keep state level statutes in mind when you're thinking about limitations on police accountability, because we see these come up so often, and and a lot of people don't know about them. And, you know, just thinking about, you know, a couple of high profile cases, oftentimes it's like, why were they placed on administrative leave? Why were they, you know, why are they still on payroll while this is being investigated? I know that was a big issue with Breonna Taylor. It's because Kentucky has a really robust law enforcement Bill of Rights statute. And that's even what the chief said, is like, I would love to not have these guys on my payroll right now. It's creating a lot of public outrage, but the state law mandates that we do this. And so I want to talk briefly about how this impacts, how law enforcement Bill of Rights statutes impact independent oversight. And independent oversight is this kind of, you know, it's part of employment consequences. And unfortunately, it hasn't been as effective as I think a lot of people would like it to be. In theory, you know, civilian oversight boards, independent auditors can be this great way to kind of democratize police accountability. But so often they really run up against so many limitations that already exist through LIBOR laws and through union contracts. So, you know, the pros are obvious, right? They're going to increase transparency in disciplinary practices. They give the community a voice in what's happening. They're a vehicle for community participation. But on the other end, you know, it's really hard to create a civilian review board or a police accountability board that has the powers to do what they need to do to be effective in any way. So union contracts and labor often say that these boards can't participate in discipline or even recommend discipline in some situations. Oftentimes they limit what information they can use to even investigate a matter, limiting the ability for there to be subpoena power or even to get really basic records due to the confidentiality protections that are in LIBOR and union statute or union bargaining agreements. Limitations on power to compel participation. They can be 100% voluntary on behalf of the police department. And so they may be good on that when it's a small issue. When it's a big issue, they might just not show up. Often there's lack of funding and staffing. If it's not a professionalized civilian review board, it's going to have a really hard time, you know, just getting everything together. I mean, you all have probably at this point in your lives and careers worked in volunteer-based groups and worked in ones where everyone got paid. And I'm sure you found that the volunteer ones were probably got a lot less done than you know, paid gigs that you worked on or places where you knew you were going to have resources available. And I think even if you were able to put together a civilian review board that had all the powers that you want, oftentimes it's the mayor who gets to appoint it. The mayor is the one who's going to have to deal with a big dollar amounts if there's ever a settlement that results from a police misconduct case. Or any kind of accountability for the police department. That looks bad for them often. So if they're the ones who get a point who is on these civilian review boards, the review boards are going to be less impactful oftentimes, and they're going to, there's going to be loyalty to these mayors and other elected officials. I would also say that, police are often overrepresented on these boards. A couple of different cities have, seen this as a problem and put a limitation on it. Denver has a really strong civilian review board, and they said, we don't want any, current police officers or former police officers, because, we've seen in all these other cities that they come in and they, know a lot more than the average civilian on the board and kind of take over and exercise undue influence over the board. But that's often a problem, even if you put together a board with a lot of the powers that you would want to see. And so, just to close the loop on civilian review boards as a way to strengthen employment accountability and employment consequences. Oftentimes a lot of the grassroots groups that we work with and advise, that's kind of their go-to reform that they want to get enacted when they come and talk to us. And we always, try to be very transparent about what we see as the limitations, but then, direct them as much as we can towards finding, getting in place a board originating ordinance that would give them all the powers they need, specify and mandate funding at the front end, and also just be, aware of all the different statutory limitations and collective bargaining agreement limitations that might preempt the things that they want to do. And so, after kind of going through all those different forms of accountability and their limitations, even though I'm going to go and spend a lot of time about all the limitations on civil rights cases, we do this work because we think it is, probably the most robust and effective form of accountability for police and police misconduct that there is. And really, typically, when we talk about, civil accountability, we're talking about, challenging police misconduct in federal court. The reason that state court hasn't really been the best avenue for civil accountability is because so many state constitutions and statutes build in really, really expansive immunities for government agencies and their employees. And so things are not great at the federal level. We're going to talk about that in a minute. But they are they're more surmountable often than state courts. And also we find that federal courts, it's funny to say this with the Supreme Court we have right now, and even some of the federal courts we have right now, but tend to be a little bit less political than state courts generally. And you guys all might know this if you've taken Fed courts, or probably even learned this in con law. Constitutional claims are brought through a statute called 42 USC section 1983. It basically says you have a private right of citizens have a private right of action to enforce the Constitution. And there are kind of two civil rights cases that one can typically bring. You can sue the city and the department under a doctrine called Monell, named after Monell versus Social Services, which kind of created this avenue for holding municipalities and cities accountable. Or you can sue the individual officer. And I'll just say up front that the limitations you might just say, why sue the city? Of course, they have the deeper pocket. They're the ones who can create reforms. In practice, being able to bring a Monell claim is really difficult. You have to be able to, show a connection between an existing policy or practice that the city has in place and the harm that your client experienced. And so some circuits really enforce this in a really strict, severe way. I don't know if there's any folks here who are based in the Fifth Circuit, but that circuit in particular, which is primarily where we practice and through our co-counsel program, has said that, you need a very large number, and it has to be really similar conduct to have put the city on notice or to constitute a city custom or policy. And so it really is, you know, an incredible burden, particularly for civil rights practitioners who are, you know, often solos or, you know, working in a small firm with a limited budget to be able to kind of put together a case of the scope you would need in order to hold the city or the department accountable. So then you're kind of, you know, left with the individual officer. And, you know, I want to just touch back on what we talked about at the beginning of our conversation, which was, you know, the importance of accountability. And, you know, I talked about it in a practical sense of accountability, you know, that the trainings are fine usually. The policies and guidance that are, you know, in the written form are usually what you would want to see. It's that those things aren't being followed. And, you know, that's something that I think we've kind of found in the court as it's talked about the purpose of civil rights cases. And, you know, in civil cases being a opportunity to obtain damages in particular. And so the Supreme Court, this is a case that we cite a lot in our amicus briefs about why it's important to allow victims of police misconduct to be able to sue, is that it's a deterrent. Oftentimes people think about, you know, these are civil rights lawyers, they're just trying to get money, their clients are just trying to get money, this isn't, you know, the way that we make change. But the courts have said that the whole purpose of being able to sue, or one of the dual purposes of being able to sue for constitutional violations, is to prevent them from happening in the future. And, you know, Carey v. Pifus, which is a 1978 case that the court talked about, was, you know, was a civil rights constitutional law case where they said, you know, paying damages is a way to stop this from happening in the future. A police department, a city that gets in trouble and has to pay a lot of money is going to think twice again before they continue the conduct that they engaged in before. And, you know, the court has also recognized that it's an important form of pushing for broader reforms and pushing for changes in government. So as I mentioned, you know, paying damage awards isn't only just about, you know, compensating the individual victim. It's about, you know, getting those departments to change their practices. And if you have a department that just keeps, you know, spending taxpayer money to pay off police misconduct cases, then eventually, you know, taxpayers are going to get upset and say, we need a new mayor, we need a new police chief, we need a new system for accountability. At least in theory, that's what the court was thinking when it said that, you know, there's value in having people be able to sue for damages. And also, you know, I think that this has maybe come off a little too plaintiff centric and a little too civilian centric. So I want to, you know, pivot and just say that, you know, a lot of police officers, I think, you know, want to do a good job and want to be perceived well and want to, and you know, would want to make sure that their colleagues or the people who aren't doing a good job face some kind of consequences, so they're not lumped in as, you know, as being as the same situation. You know, I hate the bad apple and the good apples and bad apples police officer analogy, and the bad apple spoils the bunch. But I really do think that that's the perspective of a lot of law enforcement officers. Back in 2017, the Pew Center did a survey, and, you know, officers were broadly supportive of accountability reforms as a way to rebuild community relations. This was, you know, kind of after the murders of Philando Castile, and there was kind of a rash of high-profile police shooting cases at the time. And, you know, they agreed that, you know, for the most part, you know, police officers who did a poor job consistently faced any accountability. And they said that they would be generally supportive of there being more accountability, and that there was a sense that that would make their jobs easier long-term. So I'm clearly a true believer in civil rights cases. I think that they can result in reforms. I think that they can result in deterrence in the future, and they can rebuild. Real accountability can be a pathway to rebuilding policing community relations. But unfortunately, even though I think this is the most effective and available and accessible form of accountability for police misconduct, there are a lot of restrictions still. Constitutional standards are hard to meet. You know, you kind of look at the prima facie case, standards for some of these claims, and you're like, okay, that's not that hard, but the way that the courts have interpreted them have made them very hard for plaintiffs to kind of check all those boxes. First Amendment retaliation claims, the court just agreed to hear Gonzalez versus Trevino next, or this term, and that's on the First Amendment retaliation standard, where essentially, you have to show a complete absence of probable cause in order to state a First Amendment claim for a retaliatory arrest. The plaintiffs in this case, or the petitioners at this point, are advocating for being able to show other evidence of retaliatory intent, and that kind of getting you past this probable cause barrier. I think it'll be, the court can't make it worse, but it is something that really foreclosed the availability of First Amendment retaliation claims for free speech proponents. Statutes of limitations. So, we talked about Kentucky in the terms of Breonna Taylor. There's a 1-year statute of limitations in that state to bring a 1983 claim. And 1983 claims, if you don't know, the statute of limitations is set by the kind of state personal injury tort analog. And so in Louisiana, Kentucky, and Tennessee, it's all 1 year. And it's really hard to develop a civil rights case in 1 year. Oftentimes people are still dealing with the physical and mental trauma of police violence. Oftentimes they're trying to get more information about what happened to them. And then in other situations where they're, dealing with a false arrest or a wrongful conviction, they have to kind of deal with all of their criminal consequences of their interaction with a police officer before they can sue because of a case called Heck. And so that makes so there are these kind of 3 states where there is a lot of police misconduct, where it's really hard to be able to even bring a claim because of the statute of limitations. And then there's the issue of finding an attorney. I said that there's a lot of people, we got a lot of members all across the country bringing these cases, but there's certainly not enough, and there's not enough to meet the demand of all the different people who are reaching out to our members and to us for our services. Particularly if you're looking in places like the kind of Heartland region, Kansas, Missouri, the Dakotas. If you're looking in the Delta region, Mississippi, Arkansas, you might have 1 or 2 civil rights attorneys who have expertise in police misconduct cases or jail and prison cases that are practicing and accepting cases. And a lot of them are retiring. So we really see a huge crisis in terms of these additional civil rights legal aid deserts that are popping up in a lot of these different regions. And then qualified immunity, which is something anytime I talk with anybody, I've got to spend a couple of minutes on, because even being an attorney for 10 years, learning about this doctrine a long time ago, it's still ridiculous that it's in place. So just as a background, you may have learned about qualified immunity in your con law class or in some of your different cases, but it is it's this doctrine that was created in the 1960s. Its current form kind of came about in the 1980s. And here's, what it says, basically. It is a question of not only were your constitutional rights violated, but is there a factually analogous case where the officer engaged in the same conduct? And if the answer is yes, you can move forward and go through all the rigors of litigation to see whether you can prove your case. If the answer is no, your case is dismissed. And I think this was a doctrine that I understood, just being a general civil rights practitioner. But when I started doing police misconduct work, I think that was really where I saw how problematic it was. Situations where, someone gets shot in the back, someone gets attacked when they're being surrendered by a police dog, where their cases are getting dismissed, or where civil rights attorneys aren't even bringing their cases in the first place because they know they're going to have to contend with this doctrine. And, I think qualified immunity is often touted as being this doctrine that, gets rid of frivolous cases, protects police officers from, financial ruin and the burdens of litigation. But in reality, it's maybe benefiting police officers in a very small percentage of cases, because the Constitution is probably what's going to be protecting them against a frivolous case. But it's really harming so many real victims with very tangible injuries and that experience very real harms from being able to seek justice in any way. And even though there's been a lot of people petitioning the Supreme Court to reconsider this doctrine, it's a judge-created doctrine that is, about 50, 60 years old at this point. I think for that reason, there's some hope that it might be that the court might take it up and overturn it. There's definitely a lot of originalist oppositions to this doctrine. It's one of those, it's kind of a rare situation where Justice Thomas has been critical of the doctrine, and then also, Sonia Sotomayor has been critical of the doctrine. And a lot of these kind of lower court, very conservative judges who you wouldn't think would be, at the front of the line, advocating for victims, plaintiffs, or people who have been victims of different types of governmental misconduct, coming out and saying this doctrine makes no sense. Don Willett in the Fifth Circuit is probably qualified immunity's biggest critic. And he is a Trump appointee and not somebody who typically sides with plaintiffs in these types of cases. And so notwithstanding that, I think there's a real recognition and a strong push to get rid of this doctrine in federal courts and some legislative advocacy efforts at the federal level, we're seeing many more opportunities at the state. And the idea would be, and this has been done in Colorado and New Mexico, would be to create a state court cause of action to vindicate civil rights, and then prohibit qualified immunity as a defense. Make sure that there's attorney's fees so people can find lawyers to be able to bring their case. And, we've kind of seen it in two forms. We've seen the Colorado form, which, is only law enforcement. And then we've seen it in the context of New Mexico, which is all public employees would lose their qualified immunity defense. And, honestly, it comes up the most in police misconduct cases. It was, originally a doctrine created to protect the police. But I would also say that, there's a lot of other examples of qualified immunity leading to really horrific and harmful results where law enforcement isn't involved. Educator sexual assault cases where they, harm their students. Oftentimes qualified immunity is what gets them off the hook for civil liability. So, just having, so MPAP's position would be one that covers all public employees, even though we're not necessarily taking those cases because this doctrine does not make any sense in, the context of law enforcement or public employees more broadly. And so I know you all, it's late and I want to make sure you all have time to ask any questions you want to ask. So I just want to wrap with what you can do. Become a civil rights lawyer. Since I'm talking to law students, I always want to say, if you're still trying to figure out what you want to do, kind of what area you want to go into practice, civil rights law is an incredibly rewarding venture. I would say all of our members, we get to talk to a lot of our members who are at the end of their career. They've been doing this work for the last 40 years. And, even though these cases are really hard, they're really draining. They, sometimes will say, I've never worked a day in my life because I'm doing such meaningful, important work that's intellectually, stimulating and, the kind of law you want to practice when you go to law school. So plug for all of you to become civil rights lawyers or at least take on these cases. But, I also think that, this isn't something where we're going to litigate our, way out of this problem. Advocating for the end of these accountability barriers, ending qualified immunity, extending statute of limitations, changing use of force standards at the state level to include an accountability measure. And then also, just thinking about these different ways that we can make employment consequences more viable through eliminating these law enforcement Bill of Rights statute limitations and, being as effective as we can in limiting the scope of collective bargaining agreement protections. And then, just really amplifying accountability as a public safety measure. As I mentioned at the beginning, there's always so much focus on, we need more training, we need different policies, we need X, Y, and Z. But in reality, accountability could go a really long way. So with that, I will stop sharing my screen and I'm happy to answer any questions.
Lauren, thank you for that. Also, thank you for the plug at the end. I think one of the areas where we've struggled, or I've struggled in the past with some of our speakers, is connecting the great work that you're doing to more of a career fair type approach, and ensuring that our students are aware of the different career paths that are available from that for them, recognizing their soon to be held degree as well as their passion in space. Folks, I leave the floor to you. What are your questions? What would you like more information about? What accountability measures have you uncovered in your research around your local policing departments? Any of the mechanisms that Lauren highlighted earlier at play? To what degree of success? Natalie.
Thank you so much, Lauren, for that great presentation. While you were speaking, I did have questions when you were talking about the community-based accountability, and then you talked more about it and you pretty much answered all my questions. I've encountered a few efforts in my community to build up more community engagement. And you very well set out the challenges to that. One thing I'm curious is, I only know my community. I don't have experiences elsewhere. What can you say about this issue of transparency? I know you talked a lot about the Bill of Rights, but what communities could we look to if we were looking for models of places that were trying to respectfully, recognizing the needs of all sides, open up and be more transparent, whether that's the police department being more transparent, or somehow, I don't want to say loosening the Bill of Rights, like you said, like they don't deserve due process, but making them more reasonable. Where could we look to as a bar so we could compare what we're seeing in our communities?
Sure, that's a really great question. And, I think kind of looking at the state level, California, I think, really took a very measured kind of intermediary approach on this. So, instead of saying all police misconduct records are open to the public, you get to know everything that's going on, they really kind of identified the different areas where, is this misconduct causing harm? So, incidents of racial profiling, incidents of use of force, and ones that have been substantiated or corroborated. So it wasn't just kind of like any person who was mad at this officer, could file a civilian complaint that everybody got to see. That it was really kind of limited to ones that had been validated through the internal affairs process. And I would say that that's, not ideal for some reasons, but I do think it is a kind of nice middle of the road. And I trying to think of the cities that have done within California that have done the best of making that information accessible, so you don't have to kind of go through the open records process. I think San Jose, at least at one point, was trying to get that information kind of public and accessible to the public. Chicago probably has the best, database that's kind of, partnered with civilians to build. But I would say that that's, California, I think, is a really good kind of state level model for a way to, still acknowledge and protect officers' privacy rights and make sure that they're not being publicly impugned for, things that they didn't do, but still giving the public access to the information they need to pursue accountability measures.
Yeah, that's really helpful.
Oh, and I was just going to say, I'll put my, email in the chat. I don't know if you have it otherwise, but feel free to reach out to me if you have, questions that you think about, or if you do end up wanting to do research or eventually work in this area. So.
Folks, we do still have some time. Did this raise anything? Did this make you reflect on your work in a way that you feel like sharing?
I was just gonna say, last week, our clinic talked a lot about qualified immunity. So this was just a great follow-up to our conversations. And I feel like I had a lot of questions last week after me and my classmates had discussions that you answered. So thank you for that.
It's almost like Professor Robichaux and I coordinated or something, and we
Right.
decided to build upon each other. Awesome. Other thoughts, feelings, reactions? All right. Well, I won't keep pulling. But Lauren, once again, thank you, thank you, thank you for being here, for providing this information, but more important, for doing this work. It's wildly inspiring to be able to share a virtual room with someone with your expertise, experience, and dedication to driving this cause forward. So from again, I can only speak as a citizen of DC in this moment, but I am very grateful for the work that you are doing. So thank you. Thank you for joining us. Folks, students, fellows, thank you for being here, for adapting with me. We will be back, same channel, same time, next Tuesday to get a further read on the work that you've been doing. So in the meantime, if you've not completed the amount of time that you were hoping to spend with the fellowship, whether it be a year, a semester, or longer, please do so. Again, it's column I in the research identification themes. In the meantime, as challenges arise, feel free to reach out to me. Thank you for being here and enjoy the rest of your evening.
Thank you.
Cheers.